Impact of Influence.
Covering true crime throughout the Southeast.
Hello, friend. Matt Harris and Seton Tucker, always grateful you're spending time with us. We're going to attack the Rose Petal Murder trial in a second with a conversation with Zachary Hughes' defense attorneys. We've already talked to the prosecutor in a previous episode, but the defense attorney's up next. And before we get to that, I want to tell you you're part of the Evergreen Podcast Network. Support our sponsors. Can't do without them. Can't do without you. And we'd love you to join the conversation by going to Facebook, Impact of Influence. Once there, you'll be able to jump over to the YouTube channel. And we need subscribers for that to keep doing it. And of course, rate and share and comment on the episode. We are so grateful and appreciate it. So a little background in case you haven't been following. But again, in the show notes, we'll list all the Rose Petal Murder trial episodes we've had. But Seton, for those who haven't done that yet, here's a little bit of the background.
Well, and you should definitely listen to our episode with Walt Wilkins because this would be a good balance to listen to both.
He's the prosecutor, yeah.
He was the prosecutor, or solicitor in South Carolina.
Yeah, that's what they call him, right? Yeah.
So in October of 2021, 41-year-old Christina Parcell was found brutally murdered in her Greer, South Carolina home. She was stabbed over 30 times. It was dubbed the Rose Petal Murders because there were rose petals scattered around her body, and that's Fitsnews coined that. Now, she was involved in a very bitter custody dispute with the father of her child, and during the course of her death investigation, there were child pornography materials discovered, and her former fiancé is facing charges for some of those things. Now, eventually, an arrest was made of Zachary Hughes, and he was not the father of her child or her fiancé. He was a, late 20s?
Yeah.
Juilliard-trained musician. He has now been convicted of her murder.
So we, as you said, we talked to the, as they call him, solicitor in South Carolina. Now it's time for the defense team. So we bring in our guest, Andy Moorman, has lived in South Carolina for more than 28 years, practiced law for over 20 years, assistant United States attorney, deputy chief of the criminal division of the U.S. Attorney's Office. When he's doing that, Andy supervised other federal prosecutors, had led numerous multi-year federal investigations of drug trafficking organizations, public corruption, white-collar crimes. While representing the United States as a federal prosecutor, Andy tried federal cases in almost every corner of the state. Now, Andy uses experience and skill to help those who need it most, people under investigation or indictment. And we also have Mark Moyer, spent his entire career as a trial attorney, dedicated over 29 years of his life as a prosecutor with the 13th Circuit Solicitor's Office. Began in general prosecution, where he prosecuted everything from DUIs, domestic violence, traffic violations, and magistrates and municipal courts, to more serious offenses in general sessions court. And Mark then became head of Greenville County's drug unit, prosecuted drug cases ranging from simple possession to drug distribution and manufacturing to complex narcotics trafficking and conspiracy. He followed his assignment as head of the drug unit by serving as deputy solicitor of Pickens County while managing the Pickens office, continued to try major drug felonies. Back in Greenville County, Mark spent more than 15 years heading the violent crimes unit. And the first question I have for both of you is, you came to the dark side after being prosecutors. I'll start with you, Mark. What caused you, or why did you become a defense attorney?
Well, that's pretty easy to answer. So the retirement is available to state employees after 28 years for prosecutors. So the 28th year struck right in the middle of COVID. So I decided to give it one more year, wait to see how COVID shook out. And then after about 29 years of experience, I decided it was time to move on and branch out and see how I could do in private practice.
And the same question for you, Andy. All those years of prosecuting, all of a sudden you're on the other side of the room. How'd that happen?
So like Mark, I think it was sort of an evolution in my career. One thing that I think I could say for both of us is, you've probably heard the phrase true believer, right? Neither one of us is a true believer, meaning we pride ourselves in trying to be objective, and professional and thoughtful. So, a lot of people have this idea that if you're a prosecutor, you wear the white hat and you have a certain point of view. If you're a defense attorney, you have a certain point of view. And really, my view is good lawyers represent their clients, and regardless of what the setting is. So, to me, it wasn't a huge jump. Representing the United States of America as an assistant United States attorney was a tremendous thrill, probably one of the greatest honors of my life. But it was time to do something else. And the only thing I would say is, towards the end of my career, we began having a lot of government shutdowns. And it's a real drag when you work for the government. You should be able to depend on a paycheck. But when the government's shut down and you miss your check, that also sort of makes you understand, maybe I should have a little more control over where my check's coming from and what my check is. So,
Do you feel any different as far as pressure being defense versus prosecutor? Mark, what your thoughts on that?
Well, it's a different kind of pressure. You have an individual sitting at the table with you, as opposed to representing the state. So both Andy and I are both quite competitive persons to begin with. We also believe strongly when we take a case or represent somebody. We believe in our case, believe in our person. So there's always that pressure. But yeah, it is a little bit different when you have a person sitting at the table with you, depending on how things go.
Andy, does anybody give you crap about being defense? Your former prosecutor friends?
so it's just it's so funny when funny is probably not the right word, but it's ironic when you have a serious federal case, for example, and the federal agents who prosecute the case that you're defending now, you worked with closely for 10 years. And the prosecutors who handle the case you work very closely with for 10 years and in some instances supervise. So it's different, but it's a good difference. And to Mark's point, having someone place his or her trust in you and having, everybody's a son or a daughter or a brother or a sister. And that's a tremendous honor to be able to help somebody in need like that. And there's a lot of pressure, but there should be, because this is very serious work.
Okay, so let's get to your representation of Zach. Obviously, he is very different than the average defendant, Juilliard trained. He had many friends and family there to support him during the trial. Tell us about when you first met Zach, how you came to represent him, and what it was like working with him.
Sure. So
I'll defer to Mark. Yeah.
Yeah.
Let me start off with that question. So the case started off with me. As I told you, I worked for the solicitor's office about 29 years. And so this case came to me just about 2 weeks after I left the solicitor's office and went into private practice. And it just so happened that another attorney referred the case to me. I was able to meet with Zach late one Sunday night. And this is while he was on the street. He had not been arrested yet. The law enforcement had made some overtures in his direction. And so I was brought in to represent him. And, you could just tell right away, this was not your ordinary client. Just extremely smart, sophisticated, a great conversationalist, just a pleasure to be around. And you could, that vibe came off just right away. And so, yeah, it was right about 2 weeks into my career into private practice. So this case has been my entire private practice.
Was it when you say it came to you, was it assigned to you or you just heard about, how did that happen?
No, so another attorney referred the case to me.
Okay.
Another attorney knew some of the people involved. This attorney knew I had just gone out into private practice and just referred the case to me. I got a phone call, I think on a Sunday morning, and I met Zach on Sunday night, and we were off and running.
Okay, so just prior to the start of this trial, I know there were a lot of motions going back and forth. The judge decided not to allow the evidence of the child's sexual abuse materials into evidence. and that was all discovered during the investigation of Christina Parcell's death investigation. What are your arguments against that ruling?
So I'll take that. I think it's important. One of the things that's sort of unique about this trial, or may not be unique, but I thought was unique from my experience, is that the public did not have access to arguments that were made outside the presence of the jury. And so much of this trial happened outside the ability. Obviously, the courtroom was open to the public, so if you were there, you could see it. But just as a general proposition, the public did not have access to those arguments. And so your question touches on the vast majority of what occurred outside the presence of the jury. The child pornography, we believed, was extremely important in two contexts in the case, really in three contexts. First, as it relates to the state's case and the murder prosecution, right? An element of murder is malice. And so our position was, and I said this in closing arguments, that if Zach acted for the purpose of saving an innocent child, he was not malicious. So the first relevance of that was to show that she was in danger for the purpose of Zach's intent. He didn't have an angry heart or a wicked heart. He had his motivation was to protect an innocent child. Second part of the second legal basis for the introduction of this was the defense of others. And we filed a 48-page pleading. So over the weekend between the end of the first week and beginning of the second, the state moved to exclude our defense of others argument. And we responded literally with a caption entitled, Defendant's Response to State's Request to Prevent Defendant from Defending Himself. I mean, we thought that was so important. We tried to put that in the caption. But bottom line, under South Carolina law, if one person acts to defend another, if the person who was defended could have defended herself, so let's say Mark was in trouble and I acted to save Mark. If Mark could assert self-defense, then I could appropriately defend him and step in his shoes. So the argument was this child was being sexually abused by her mother and her mother's boyfriend. We had an expert come in to talk about the extent of the abuse. And so we believe that under the law, Zach had the ability to stand in her shoes for the purpose of defending her. And lastly, the third legally viable channel for the introduction of this evidence was on at least two separate occasions. It was our view that the state opened the door to this evidence in their case in chief. Unfortunately, the judge disagreed with us as it related to the admissibility of that evidence, which happens. But those were sort of the big three legal theories that we believe rendered that evidence admissible.
I'm going to go a little deeper in that in a little bit, but I also want to, so from Jump Street, from the beginning, you felt the case was going to be, your strategy was that he did not have to act with malice, one. And number two, I have a question is, when did you decide I'm not doing the opening statement where it normally goes right after the prosecution does their statement, then usually the defense goes, you guys decided not to do that. So both of those strategies, walk me through that, how those came to be. I mean, the malice thing was that from the Jump Street, and why no opening statement at the beginning?
I'll defer to Mark on the opening statement since he opened. Yeah.
Okay.
Yeah. So I'm glad you picked up on that, Matt. Yeah, that as you noted, we did do an opening statement, but it was not at the beginning of the case. And as your question suggests, that's not very typical. Usually, both sides give an opening right away. So that was something we had talked about off and on for quite a while, and just the pros and cons of it. We knew going into the case that there was a possibility that we could be thwarted on some of our defense strategies. Mm-hmm. And we believe that would become more apparent throughout the state's case. So one of the reasons we did that was so we could have a clear understanding kind of where we're going with our defense and some of those legal theories. Sometimes if you get that out at the very beginning of the case and then you are unable due to some judicial rulings to follow up with that, it may not come across so well to the jury. And the other side of that, I think, to explain the strategy behind deferring the opening statement to when it was, was that we wanted to have the maximum impact on the jury. And so we thought that deferring until that moment when we pretty much told the jury what happened. I mean, we didn't go into specifics exactly, but we told the jury that Zach did this, and so we thought it would have maximum impact to come out at that particular time of the trial.
Now, a question for you on that is, was part of the strategy also to not let the prosecution know your strategy? Or do you think they knew where you were going to go?
That's a great question. I think that was part of it also. And so I don't know what they thought we were going to do. But that was part of it, I would say. Yeah.
See?
Okay, so in another ruling, the judge did not allow this defense of others theory. I think you just mentioned that. Do you think if the jury heard the reasoning behind why Zach killed Christina Parcell, that maybe would have changed the outcome?
Yes. I think it's possible. Obviously, it's hard it's hard to speak intelligently about the probabilities, but I've seen some media reporting where jurors have been interviewed and they've said that could have made a difference. So yes. And Matt, just going back to the question you asked too about sort of in which box we put the child pornography evidence and sort of what our thoughts were. And Mark said this in his opening statement. Zach made clear to us that he wanted to tell the truth from the get-go. And we knew that was going to be something that was important to him. And part of our task as his lawyers was to determine what impact did the truth have on the way the law applied. And so we believed that the truth as he was going to tell it and as it was would make him not guilty again in the context of murder, defense of others, and otherwise.
One question, can I follow up on that? The state's argument is that he did not know about the child abuse for sure, so, right? That's their argument. What's the answer to that?
And that's laid out in that 48-page pleading. So this is an extraordinary case because lots of times defense counsel sort of keep the strategy very close to the vest all the way through until the very end. Over the weekend, the state moved to exclude our defense of other strategy. And so we were at a crossroads over the weekend. How much do we need to divulge what the strategy is? And we made the decision that it was critically important to hit this head on from the beginning now that we're going to start our case. And so that's where we filed the 48-page pleading. But if you look at our pleading, it lays out very carefully the law and how it applies. Bottom line, under the law, if a person has a reasonable belief that they are in, quote, imminent danger of serious bodily injury or death, or if that person was actually in imminent danger of serious bodily injury or death, that person has a right to act in his or her own defense. I'm oversimplifying a little bit, but under the law, it's either if you have a reasonable belief or if you're actually in danger. And we showed that this child was actually in danger. We were prepared to show that with thousands of images.
And prepared to show it that he knew it. Zach knew it.
Well, you don't need to show. But you don't need to show. So
okay. So reasonable belief, right?
Oh, yeah. So you don't need to show.
So we had evidence. We had evidence that we had strong evidence that he was on notice that it was a possibility. So we were prepared to prove that wrong, that he reasonably believed it. But again, if he stood in her shoes, this child would know better than anybody, right? So her knowledge would also be imputed to him, right? Because he stood in her shoes. But again, aside from that prong, I think the evidence would show that it was undisputed that this child was in imminent danger of serious bodily injury or death. And let me say one other thing, if I could, about this, because this is what probably the most unique aspect about this whole case is that the state couldn't get past this, and a lot of people in the just a lot of members of the public can't understand this idea that, well, if the child wasn't even home when this happened, how could she be in imminent danger? Okay, how can that happen? Right? And this is very important. The mother died on October the 13th. 6 days later, on October the 19th, law enforcement finally finds the images of this child pornography. Okay, by the way, this crime was reported years earlier and they didn't find it. Okay, but anyways, but that never came out. But 6 days later, police find the images and they take the child into emergency protective custody under South Carolina law. The next day, a family court judge on October the 20th says, "Yep, I agree. The child should be taken into emergency protective custody." Under South Carolina law, that is only appropriate if the judge makes a finding that the child is in, quote, imminent danger of serious bodily injury or death. So 6 days after the mom died, we have a police officer admit that the child's in imminent danger of serious bodily injury or death. 7 days later, we have a family court judge make that finding. That is evidence of imminent danger, right? So the perpetrator, one, has passed away and the second's in jail, and a judge still finds this child's in imminent danger. And so that was part of the strategy as to why we could show, and this was in the pleadings, Judge, we're prepared to prove that this child, even though she wasn't there, was in imminent danger of serious bodily injury or death based on the state's own witnesses and a family court judge.
Gotcha.
But none of that came out.
Right, right.
So it did seem like Zach had this big desire to tell the truth. In fact, when the judge admonished him a couple of times for making outbursts, he said, "I put my hand on the Bible and said I was going to tell the whole truth." You've spoken to a little bit about, was he allowed to tell his whole truth and present an entire defense?
I'll let Andy answer that since Andy handled the direct of Zach.
So let me preface this answer by saying this scenario brought about a profound fork in the road, right? Sort of competing interests that are very, very important. One, you have the judge's obligation to apply the rules of evidence appropriately to the facts of the case, right? That's an incredibly important obligation the judge has as an umpire. The other side of this is due process and a defendant's right to tell the jury why he did what he did, or especially in a case like this, the fullness of the events that occurred. And so there was a tension, obviously, between Zach and the court, and there was a back and forth between the court and me during Zach's direct examination. And I think one of probably the more heated or significant portions of the trial was there was a point when the jury was let out and the court who did the very best he could under very difficult circumstances. The judge looked at me and said something to the effect of, "Your Honor," or he said, "Mr. Moorman, you need to," he didn't, I don't think he said this specifically, but the import was, "You need to control your witness or make sure your witness complies with my orders." And I responded to the court. I said, "Your Honor," I said, "I'm asking questions that are designed to elicit information that's consistent with your ruling, but he's also on trial for his life." Mm-hmm. And so,
when you put him, when you put him on, how much of his testimony was rehearsed with you guys or just on his own? Because that was one of the things that people were saying later, that it seemed a little bit too emotionless, too much whatever. Was this, did you go through those steps with him and what advice before you put him on the stand, that sort of thing?
So, and we got to be careful about attorney-client privilege. So
yes. So whatever I get that. Yeah. Like the basic concept of that.
So I think we can say this. We spent hours and hours and hours talking to him for the purpose of learning about the story, about knowing every detail. There are also portions of the story that we deliberately did not rehearse much at all because we felt like it was important for that to be raw. And so I don't want to say which portions.
Right. That's fine.
But Mark and I can tell you, we met, I mean, I can't even count the hours. We met with Zach for the purpose of learning about the story, learning about why he did what he did, who he was. And as you all probably know, a trial is a very fluid circumstance. There's no way to eliminate the possibility of surprise. But the only way you can be as prepared as you can or deal with those fluid situations is if you know as much as you can. And what our goal was. And we had to do that because we constantly had to pivot based on rulings of the court that changed our presentation.
Well, Mark, were you surprised by any of the feedback that came out that the jurors were didn't really take well to his testimony, that he showed a lack of emotion. Were you surprised by this feedback?
I had not heard that the jury members actually had that response. We have heard about that from some other persons in the community who've been watching the trial, people who observed it. It's very unfortunate, and I wish people could have a little bit of grace when they consider everything that goes into having to testify. I mean, it has been said that public speaking is the most feared task or thing that a person can do, right? I mean, if someone's just standing in front of a group, uh, you know, reciting a recipe for a meal, they'd be scared out of their mind. Now compound that with you are in front of a group of people who are going to be deciding, your fate. You've got cameras, you've got judges, you've got lawyers who are going to be cross-examining you. You've prepared. Think also about the setting that he came from. It's no secret he'd been incarcerated the entire time leading up to his arrest, up to his trial. I think he had just a couple of hours of sleep the night before. He's in kind of isolated cell by
Packed
himself.
courtroom,
Packed courtroom, yeah.
Packed courtroom, absolutely. And then you're preparing. And so I don't think it should be any surprise to anyone that you can't manufacture emotion, right? It would have been even worse for him to try to manufacture some sort of emotive performance in anticipation of that's how a jury would want him to come across. So, yeah, it is a little bit disappointing, but I hope people will just, like I said, give him a little bit of grace and try to understand the setting that we're dealing with.
Another reaction that heard from one of the jurors, I believe from one of the jurors that Jen did over at Fitsnews, and it's something I caught, and I'm not sure how many people caught, but the guy says, or whoever the juror was, male or female, says stabbing 31 times, and he goes like right, enacting it, right, like 1, 2, 3, 4, 5, and you said it in your closing, I believe it was in your closing, that it wasn't 30, it wasn't like that, right? When you hear 31 stabs, I think a lot of people say, wow, he must have been super, because you imagine this, right? Explain to us why, and you said it a little bit in your closing, why that wasn't what it was.
So the forensic exam, this is a lot of evidence in the case sort of explains what happened in that house in a lead up. It's just so ironic. The forensic examiner who did the autopsy, his last name was Rose, right? Claire Rose. So in Dr. Rose's testimony, she talked at length about the different types of wounds. There were incised wounds, and then there were stab wounds. Well, the incised wounds were very superficial, right? The stab wounds were less superficial, but the incised wounds were so superficial that they didn't even look at the depth. And there were many, many more incised wounds as opposed to stab wounds. And Zach testified very truthfully that he tried to do it in the most humane way he possibly could. But he realized that had he done that, it may put other people at risk or in danger. He didn't want to do it. So he was stuck with this method. And we got out of trial that at the time he was about 160 pounds. She was 163 pounds. So they were very physically evenly matched to some extent. There was a struggle in the house. So what I attempted to do in closing is to explain that this was not the malice, the way it happened. You can't control, if you're going to decide how to do it, you can't control how it was going to happen, right? You can try to plan, but bottom line, he didn't want any of this to happen. And when he got in the house, I mean, he talked about he couldn't do it. Like his body was actually fighting him because he didn't want to have to do it. So it wasn't the argument I made. I think the evidence showed it was less malicious, and it was just a state of chaos.
I have a question about that. So are you the incision wounds or whatever, they don't, when they say 31 stab wounds, whatever the number was, 30 something, they doesn't mean they were deep stab wounds, right?
No.
So anything can, like if she puts her hands up, that'd be a stab wound.
Yeah. Well, no. So there were 30. So I think and I haven't looked at the report for a while, but I want to say there were like 35 sharp force injuries. What was sharp force injuries?
Oh, okay.
Of those 35 sharp force injuries, and again, I could be off, but I think something in the realm of maybe 11 were stab wounds. The other 24 were inside superficial wounds. So the
Gotcha.
vast
Yes.
majority were superficial wounds. And we got to that on cross-examination out of Dr. Rose. I mentioned that in the closing argument.
Yeah. Because that's when you read the newspaper reports, it's always 31 stab, like whatever, right? So,
Yeah.
and that's why they imagine like he's so angry, he's just going bam, 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 bam. Not the case.
Not right.
Okay.
Okay, I want to circle back to there were a few times that y'all argued that the door was opened by some of the testimony. Can y'all go over what about which times you thought the door was opened and basically your argument on that?
So Mark had one and I had one, and Mark's was first. So I'll let Mark go first.
So mine was when we were doing a proffer of the witness, Bradley Post. So I don't know if you saw that. It was outside the presence of the jury, but the judge had made rulings. Excuse me. Sorry, the judge had made some rulings. Yeah, that time of year. The judge had made some rulings that a lot of the questions that we wanted to ask, a lot of the areas that we wanted to go into with Brad Post, we were unable to do. So we had to put all that evidence into the record by way of proffer. And one of the questions that we asked, and just to back up, so Brad Post had his attorneys present. He was pleading the fifth on a good many of the questions that we asked. Because, as you know, he's been charged with all those numerous sex-related offenses regarding the child and the child pornography.
And he was there in orange, and he was there in shackles and a jumpsuit. He was, just to remind our listeners.
Yeah,
he was. He was brought out. He was led out by guards from the holding cell into the courtroom. And so we were, he was taking the fifth on Mose. He's waiting for his trial. So did not want to incriminate himself. And one of the questions that we asked right towards the end of the proffer was, isn't it true that you and Christina Parcell were taking, were producing child pornography with the daughter of Christina Parcell? And at that time, he did not plead the fifth, but he looked at me and said no.
And
I
remember this, and everyone just kind of went, he just said no.
Exactly. So we believe that particular, and he had every opportunity and every right just to plead the fifth, but he specifically denied it. So we believe that opened the door to that evidence. And then Andy, as he mentioned, had an instance as well.
Yeah. So, so when Vanessa Cormelo testified, he was the guardian ad litem in the child custody case. She testified about her observations and the task she performed as the guardian during the litigation. And one of the last questions that the state asked her was something to the effect of, prior to Christina Parcell's death, what would have been your recommendation as to where the child should live? And she was very careful how she answered, and she qualified it. She said, at the time, I would have recommended that the child live with her mother. Well, on cross-examination and as an officer of the court, we have obligations to give the court a heads up when we're going to go somewhere that we think could be problematic. And I said, Judge, and this was outside the presence of the jury, I said, all right, Judge, now we have an issue because the state elicited from the guardian what her recommendation would have been before the death. Now I have every right to ask, well, what would have been your recommendation after her death and why? And the judge said, I could not ask that question. I could not get into what her recommendation would have been after the death, because that would have implicated the child pornography. So we asked that the jury be excused, and we proffered that information. And the guardian ad litem said specifically her recommendation would have changed because of what she saw in the pictures. And I think this is correct, that she said that had she been aware of those photographs and the abuse that was occurring, she would have gotten the child out of the house immediately and away from the mother.
Immediately is a key word in there, right? One of the key words. Yeah.
Mm-hmm.
And that also, as a layperson, because we saw it in the Murdoch trial, kind of is it seems like it opens it because you've gotten into character just alone, kind of with her talking about the character of the mother.
Well, and we briefed this again before we started. In general terms, this open the door doctrine says that evidence that is otherwise inadmissible can become admissible for the purpose of basically telling the whole story.
Gotcha.
So that you don't leave the jury with a misperception or a half truth. So, we believed it fit squarely within that doctrine, and that evidence should have come in. The court disagreed, though.
Okay, so there was a lot of clamor, during this trial. Are we going to hear from John Mello? And of course, we did not. Why did y'all decide not to call Mello to the stand?
Go for
Andy,
it,
I'll
Mark.
let you.
Who wants to take that one?
I'm guessing you're thinking he's a loose cannon, maybe. Yeah.
But
Yeah,
yeah,
go ahead, Mark.
you hit the nail on the head right there. I mean, you have to be very careful in the trial. You don't want to call witnesses you're unsure of what they're going to say. You want to have a very tight structure to your presentation of the evidence, what you want the jury to hear and to understand. And really the simple answer is there was nothing he could have added that would have helped our presentation.
And certainly not be allowed. Probably half the things he would have said wouldn't have been, if he had said something, probably might not have been allowed even, right? I mean,
that's very possible too. Exactly.
Wait, I want to talk about this. When we heard the jury charges, the judge decided to keep out the language just cause or excuse out of the definition of malice. Why do you think this was probably, I'm taking you think this is not proper, and why?
Well, I'll start and then I'll let Andy chime in. Obviously we had disagreement with the ruling that came about. We respect and understand the judge's ruling. We had a disagreement about that. That was a big part of our defense at that point of the case. As Andy told you, we had to pivot several times throughout the trial in the direction that we were going. We had the defense of others defense in mind, excuse me, to begin with. And when we were not allowed to do that, our next line of defense really was the definition of malice, definition of murder. So murder is the killing of another person with malice, a forethought, expressed or implied. Malice is defined, has several definitions. It's a dark heart, it's wickedness, it's evil. It's also been described over the years as the intentional doing of a wrongful act without just cause or excuse. So we latched on to that. And as you may recall, that was some key language in our opening that we wanted the jury to begin to understand that concept and to be thinking about it as they heard from the witnesses that we called, and particularly from Zach, about why he did what he did. So yes, the short answer is, we were hoping to have that language included. We thought it should have been.
And the jury actually came back several times during deliberations with questions about malice. So it seems like that was something on their minds.
So it was, and I also think it's important, the chronology here, just briefly, we talked about the just cause or excuse. Mark did in his opening statement after the court said no defense of others, and we couldn't even produce witnesses to try to prove it up. So that is off the table. So we pivot to the just cause or excuse, which is, we believe, black letter law. We elicit evidence to try to bolster that idea. And then in the initial jury instruction that the court gave the parties, that language was in there, that without just cause or excuse was going to be charged to the jury. Zach testified after his direct examination that was still in there. But between the direct examination and the cross-examination, the state moved to exclude it, or somewhere about that time, moved to exclude that language because we didn't have the defense of others. So the state made the argument, well, if you don't get the defense of others, then you don't get just cause or excuse. And our argument was they're a totally different context. Defense of others is a defense, whereas this goes to undermine the element of what the state's trying. It goes to intent. It's a totally different situation. But bottom line, we didn't learn until after Zach testified on his direct examination that the court was going to remove that language altogether, which was very challenging, right? So So that's sort of our last piece of evidence. And after we're done, we learned that that's excluded. The other thing that I do think is significant that we objected to, and again, the court disagreed and we respect it, but the court charged the jury or told the jury there are two types of malice, express or implied. And the court said an example of express malice is preparation or planning prior to the act, right? Well, Zach told the truth. And he said, I did. And in closing, I said, he had to because the nature of the threat was so profound and different. Nobody would have ever thought a mom would do this. So, but under South Carolina law, there's a prohibition where a judge can't comment on the facts. And we disagree. We believe, Judge, you're basically telling the jury now they have to find that he acted with malice because you've given this example that matches up exactly with what he said, and you can't do that. And when the jury came in, he charged them on the malice, but the last thing he told them was, if somebody plans prior to the act, it's malice.
Right. And that was obviously he was planning. He openly admitted to that. Yeah.
Yeah,
He did.
But that's not part of, you believe, not part of as the law is written. Planning is
Right,
not, there's no planning in that statement of.
Well, I think it's probably a generic instruction that's often given, right?
Oh, generic, okay.
I think depending on the case, it's appropriate. But I think in a case like this where the instruction has the and again, we respect the court's ruling, but in a case like this where the instruction has the effect of telling the jury if he planned, he was malicious, that crosses the line, I think, because it goes into a comment on the facts.
We talked to your solicitor friend about this case, a week ago or so, I guess.
Yeah, Walt Wilkins
Walt
last
Wilkins.
week. Yeah.
And he said that there was a plea deal at some point. Is that, you probably can't talk about, what the client said, but was there a plea deal offered, and did you consider it? Or no comment?
Well, without going into specifics, we have to be very careful to
right.
client. Every case like this, I've never seen one where there's not some possible negotiations that are out there, and potentials for trying to come to a resolution in some way short of a trial. The only thing we can say to that is Zach wanted to tell the truth about what happened, and now we just keep coming back to that.
Okay.
I would also say this, though, too. There were definitely negotiations. We talked about it, but there was never a time where the state came to us and said, if he pleads to these charges or this charge, this is the sentence we would recommend. So we negotiated. There were negotiations back and forth, but nothing was ever reduced to writing, and there was not. It was much more in the abstract than that.
Okay.
Now, we've heard that Zach has been a model prisoner. How is he doing post-conviction?
All reports are he's doing very well. Unfortunately, we've not been able to visit with him ourselves yet. He's not as successful as he was. But from the reports that we're hearing from those who have spoken to him and seen him are that he's holding up very well. He's doing very well. Like you said, he was a model inmate. He was very well liked by everyone in the jail, from employees to fellow inmates.
Yeah, I heard there was a rumor that several of the employees of where he was being housed were going to come and attend the trial to support him.
Yeah, we'd heard similar rumors, but we also know just from direct conversations as well, he was extremely respected and well liked, both because he was a model inmate, didn't cause any trouble. In fact, the opposite. I think he helped dispel tension in many situations. But he also just a pleasure to be around. He's just a very, very, just a great guy, great conversationalist.
John, go ahead.
Oh, will y'all be involved in his appeal?
So yes, we actually have just been retained. So we are his appellate counsel now.
And how long does that, to break down the basic process, before you have to file? When does that have to take place?
So under South Carolina law, you have 10 days to appeal from a final judgment in a criminal case. So the trial ended on, I think, February the 20th, I think. So we filed 2 notices of appeals for reasons that are may bore you, but we filed the first one on the 26th of February, the second one on the 28th of February. And in the notices of appeal, we also filed motions to withdraw as counsel and for the extension of deadlines that occur until we could get his representation resolved. So we've just done that. So we've got to collect the records. That's transcript of the 2-week trial that needs to be prepared, gather the exhibits, do our opening brief. The state will have their response brief. Then we'll have a reply brief. Then we might have oral argument. So it's going to be a while. Okay. It's going to be a while.
The John Mello and Bradley Post. All right. They're both facing charges right now. Will the outcomes of those trials have any effect on the appeal?
I can't see anything. I'll defer to Mark to see what he thinks, but I don't see it.
Okay. Let's see what else. I want to do a big picture thing just for a second. How long was Zach in jail before the trial? It was like 2 years or something?
It was over 3.
3
He was
years,
arrested in early November 2021.
So I think it's November 1st, right?
Something like 3 years. So as former prosecutors and now defense attorneys, is there something wrong with the system where somebody who has not been found guilty of anything is in jail for that long? Or is it just the way it is?
That's a big question.
Yeah, it is. Yeah, it is.
So let me say this. Under South Carolina law, the statutes. I believe, and I've argued this, that the law is clear that a person who's arrested is to be released. The default is a PR bond, meaning you don't need to post a bondsman. You can it's just an IOU, sign a piece of paper, and you leave. That's the default. The way the law is written, if the person presents a danger to the community or flight risk, then certain conditions can be imposed to ensure that person comes to court. But I mean, the law is clear. The default is the person should be released. And there are cases, even in capital cases, where courts have found that it's appropriate to set bond. So the default under the law is the person should be out of jail. And the court can impose whatever conditions are necessary to make sure that person comes. But I don't know if everybody else agrees with me. And that's why you have a lot of people who remain in jail.
Yeah, there was just a case in Charlotte where the guy's been in there for 6 years. They just had a hung jury, so it could be another 2 years if they do it again. And that seems like a long time. And I'm not saying whether he's guilty or not. I'm just saying he might do 8 years without being convicted of anything.
Right, and that should never happen. The other thing that's kind of interesting, though, real quick too, is under federal law, there's a speedy trial statute. So you've got 70 days, and you can get continuances, but you're on the clock. Whereas in state court, there's a constitutional guarantee, but it's much more abstract than the speedy trial statute in federal court.
All right, I want to do that big picture thing there. Cool. Appreciate your time. It's I know it's hard out there being a defense attorney sometimes. They don't get a lot of love, but you're fighting the fight, right? So yeah,
thank you
appreciate
for the
it. Thank you guys. Appreciate it very much.
Thank you again for your time.
Thanks. Bye guys. Yeah.
Bye-bye.
It is I think really cool to hear the perspective of attorneys and strategies and the legal cases that they make for either the prosecution or the defense. And I do want to point out that most of the time, 99% of the time, we are not taking sides. We are just asking the questions and trying to get the experts to enlighten us as to what their thoughts were. So we try our best to remain as neutral as possible, but also want to dig and find out this information.
I think you have PTSD from Murdoch. We haven't really gotten a lot of comments. People loved this Walt Wilkins episode. People said, great episode. You should bring him on more often. He was fantastic.
He was really good. Really good.
Ton of great episodes. Also, a lot of people sent private messages. Someone said, helped me understand the case and the strategy more.
Yeah, cool. That's great. And we love when you reach out to us on Facebook or on the YouTube channel, which is the easiest way to get through the Facebook page, and comment there. We got a bunch of new subscribers over the last couple of episodes, and so we're still trying to crank that baby up, and we could use your help.
I know. I don't watch it because I hate to see myself on camera, but I'm trying to direct people there.
Oh, I am. I could take you look fantastic.
Oh, no, the lighting. We need to improve our lighting. We'll talk about that later.
And get a sign. Anybody want to make us a sign? Reach out to us on Facebook, Impact of Influence. Let us know about things maybe we should cover, what we're doing right or wrong, and subscribe to the YouTube channel, part of the Evergreen Podcast Company. And as always, we're grateful, friend.